noliqwetha uzabe esincedisa analyzing ityala lwayisakuba ngunozinti we-Orlando Pirates kunye neqala lesizwe iBafana Bafana uSenzo Meyiwa wathi waba kanti ke uyabulawa ngonyaka ka-2014 ephosphorus kwikhaya lwayesakuthandana naye uKelly Khumalo noyimvumi Mr Nomvethe nkosi kakhulu ngexesha lakho. Welcome to the show.
Yes, sir.
Okay,
yeah, no,
right,
that's perfect. That's perfect. Greetings to you, Manez, and to the listeners of the KNR. You've said it, Nqaba Nomvethe. I'm 10 years in East London. My office is in Beria. Yeah, great to be in the show.
Again, we are going to dwell on with this discussion because when we had a discussion here to Yokrebela, I think Sasteta about the delays.
Yeah, that was pre-trial.
That was pre.
Yeah, that was before we got into
trial. And now, the trial is on.
Yeah, very interesting.
I'm happy you mentioning Ndoba. It is interesting.
Yeah, very interesting.
Because kuko imibuzo. I have a lot of questions. We always prepare for a radio and for our viewers to make sure that we bring them umsebenzi omamelegayo. There's just a lot that is happening. Quick trial yokubulawa kaSenzo Meyiwa. And having you this afternoon is, I would say, it's a privilege because I want to understand. I want you to help us understand.
Yes.
Why kusenzeka izinto zenzekayo, and is it the way ebekufanele bakwenzeka ngayo, iphoswaphi, and where it needs to be fixed? Who is at fault? Who is not doing their job? Who is keeping things away from us as a general
interested party?
Yes,
I could say, like the view,
yes,
the followers of the case.
From the 5 men that were arrested, Mr Nomvethe, to state witnesses, to ukuva izinto zobakho abantu abafumana threatening phone calls, to masiqale nge-questioning that has been challenged. That the questioning, it's sort of misleading or confusing. Let's start there. What is going on with questioning as proceedings?
Questioning, it's a bit broad because we've got examination in chief and we have cross-examination. That is how we formulate questioning in court. Let me explain examination in chief. Examination in chief, it is whereby a state witness, remember now it's still the state case. Let me just unpack it a little bit so that people may follow me when I say it's a state case. We are at a stage now where the state is placing their evidence on record of all witnesses that have written statements in their case docket. That is called a state case. Those people will come, tell their story, being cross-examined. Then when all the state witnesses are done, the state will close its case. And then the defense will open its case. When I'm saying the defense will open its case, meaning that the witnesses of the accused and accused themselves will take the stand and give their version of events. So when you talk questioning, you're talking questioning on two-way, not on one way. But again, the questioning that will always draw attention is cross-examination. Because cross-examination is hitting hard on witnesses and trying to confuse them. Now, this is how I would want to start the answering your question. There is nothing wrong on the examination in chief. There wouldn't be anything wrong because Advocate Baloy, who is the state prosecutor, would just say, Sergeant Mosia, you were the first responder and the first expert who arrived on the scene of crime. Tell us what happened. So he will There's no much questioning. The questioning that he would be asked by Baloyi is just leading him on the critical issues that he wants to address. Maybe the witness is forgetting. But cross-examination becomes interesting because the questions that are asked are not favorable to the witness.
Yeah.
You know.
So hence there's this thing where they're misleading or confusing.
Yes, or confusing. Okay, let's first talk about who is asking cross-examination questioning. It's Advocate Tefo and the other lady Mshololo. I could say, as far as we have gone, Advocate Tefo has been so much brutal and lacking a little bit of being clinical. In terms of directing his questions to the relevancy and the gist of the matter. When I weigh them, both of them, you know, we are watching them. We are legal practitioners as well. We can see what's done right and what's done wrong. Clinically, Mshololo is being more clinical.
In terms of executing.
In terms of questioning.
Okay.
And in terms of being, brutal, but again, being procedural in a way. For example, Advocate Tefo just fought with the with the judge not so long ago. I mean, I won't go into detail. It's even on social media. Yeah. So there is a little bit of lack of a clinical approach when it comes to Advocate Tefo. But again, Advocate Tefo is more brutal on the witnesses. The very interesting part. Okay, let me just unpack as to what does this cross-examination now reveal.
Yeah.
Advocate Tefo has been so good in revealing that the state has a contaminated scene of crime.
Okay.
For example, the Sergeant Mosia is in Mosia that is taking the stand. There is a lot that has not been done correctly on the scene.
Okay.
Like, let me just put bullets on it. The first thing that has not been done is, okay, firstly, he is not quite sure whether or not that crime scene has been contaminated.
So
he said he is sure on examination in chief, but when it comes to cross-examination, there are a lot of loopholes. For example, the shells that were on top of the counter, he failed to take what we call a PR, that powder that is, when you discharge a firearm, a projectile goes, hit the target, a shell comes out, but there is a powder that becomes left in your arms.
Okay.
You know what I mean? So no one that was in that house that was taken evidence, like swabs taken on their arms just to check if the one who pulled the trigger is not in the house. Of course, they arrived late, I think after 4 hours. So that scene of crime is not, it will not stand the test of time in terms of DNA evidence, or what we call forensic evidence. Forensically, they are falling short. And remember, the firearm that they are linking these suspects to is alleged to be belonging to accused number 3. But everybody is charged with the same, offense. Probably common purpose will take place. Now, when you do cross-examination, you ask questions relating to what the witness have said in examination in chief.
Okay.
But when that stops, when you cover all the questions of what he has said, like your evidence, how did you collect this evidence, who was there, some of the questions that were asked was, did you do this or according to your expertise? And Mosia will say, no, Brigadier so-and-so told me that, this is what is happening. Of which, as an expert in the scene of crime, you must manage it. You must do your scene, you must cordon your scene, and you must protect it so that even the top,
Nothing
the
can be
top,
tampered
even
with.
if Begitele can come as a minister of police and try to step into your scene, you have a right as Sergeant Mosia, who is the controller of the scene, to step him out and say, step out of my scene, so that nobody contaminates anything in the scene of crime. Remember the Oscar Pistorius case? That scene was contaminated. Remember, the firearms were touched by hands with no gloves and all that. So here we are getting some doubts as to why was this done, why was this not done, and there's a problem there.
With the contamination of the crime scene, that puts question on the South African Police Service.
Yes, of their, I can say, incompetency or carelessness. Let's put it as a carelessness, because when you get it, another thing that we must put it in mind is that the SAP got into that crime scene 4 hours later.
4 hours later,
anything could have happened between the shooting and that 4 hours.
All right.
So that scene between the shooting and when the police arrived, anything could have happened to contaminate it, whether by people that were in the house or by anything or anyone else. Now, interestingly, Advocate Tefo is putting to the witnesses, okay, I was explaining this. You ask questions relating to examination in chief, that which was said. Then turn now the wheel and put your client's version into the witness. Now, interesting enough, Advocate Tefo is coming up with something that, okay, an eyewitness that was in the room at the time of shooting will come and testify.
Is that information allowed to be shared in a court of law?
Exactly.
It is allowed.
In fact, it is mandatory.
It is mandatory.
You must put your client's version into the witness that is sitting on the stand. Why? Because if you miss to put that version, let's say Advocate Tefo did not say that to the witness that was on the stand. And at a later stage, they bring this witness. They never spoke about it. They bring this witness that will say, no, I saw so-and-so killing Senzo Meyiwa. That evidence can be rebutted. It can be even not be admissible because it was not their version. So I will tell you the risk of it, but it is lawful because people are concerned. How could you say that?
How can the SAPS miss that information? They arrived 4 hours later at the crime scene.
They could have been misled.
They could have been misled by Abanda Bebe Paya.
By the people who were there.
Okay.
Remember, SAPS was not there at the time when the incident took place.
Okay.
And when they arrived there, and I'm not talking about, I almost said Advocate Mosia. Sergeant Mosia.
Yes.
He is an expert that arrived late. The first people that could have arrived on the scene of crime are the men in blue, the guys that are in uniform. What they do when they come into a scene of crime, who saw anything here? Kelly Kumalo will lift up her hand and anybody that was there and say, no,
this and that happened.
People entered our room and then after entering, they pointed us with a firearm, demanded laptops and all that, and then they shot Senzo Meyiwa. Probably he was trying to push them away or whatever the case may be. I'm not sure about their statements. So the police will just note down the statements. And the information that is important is the first-hand information.
That leads to a docket.
That leads to a case whether or not something happened wrong or who did what. So they could not suspect them if it was them who was giving evidence, 7 people saying the same thing. You know what I mean? So they had to, I cannot say they missed the point there. They were just misled. If the armed robbery or the house robbery didn't happen, we are not sure. We're still looking at it. But now, this is what again, I'm blaming now the SAPS. This is what the SAPS missed again when they arrested these 5 guys. When you arrest these 5 guys, what we call an identification parade should have happened. Remember, we are saying on our statements, people entered the room and there were 7 people who were sitting there, including Senzo Meyiwa. I'm thinking maybe he was the 8th one. I'm not sure. But there were many people that were there. Somebody entered the room. Nobody spoke about baraklav or covering the face and all that. Now, five suspects are arrested and they are charged of this case. Why don't you put them on parade and you call all those 7 people and say, point out who was there, who did you see? You know, even if they will say, okay, I see these people, but no one, I can't identify them. So we write a note that says identification parade failed. No one was positively pointed out. But what if the people who entered there are one of those accused? Now we are on trial. You cannot reverse it and come back to the identification parade. You know, so you would test now the version that you were given on your statements by the witnesses that were in the house against the identification parade. But that didn't happen. It would compromise the case, of course. You know, I'm sure about that.
Let's talk about the dockets.
There's 2 dockets.
Zimbini, Mr Nomvethe. Why?
There's 2 dockets. Interestingly and ironically, there's 2 dockets. It does not have to happen.
I was going to ask you, has it ever happened that
it should not happen?
For 2
dockets
one crime scene.
Okay, let's talk about suspects. You can have 2 dockets for the same suspect.
Okay.
On the following occasions. You come here at a studio, you shoot us, and we open a case docket. When the thug comes out of this building downstairs, he's blocked by the security officer, and then they shoot him. So there could be, or maybe let's say they run away when they get into Cambridge, around Cambridge, somebody identifies them, they shoot that person. Or maybe in Beacon Bay. So we could have a docket for Cambridge and a docket for Beacon Bay.
Okay.
But upon investigation, you will find out that the same suspect is linked in both cases. Then you will have 2 dockets that will run concurrently. But normally what we do, we consolidate those dockets.
All right.
So that they can form a single cause of action.
Okay.
But you cannot have a case docket for the same case number, same crime scene, same suspects, and again, 3 years down the line, you've got another docket, which are contradicting. So the state now has a doubt, has a problem that there is a first case docket that says there was this shooting that happened, no suspect, but these people that were in the house must be investigated. That forms logic, because if no one knows what happened and no one can be identified, investigate those that were there. Put them into questioning one by one. Probably they will contradict themselves, or one of them could confess. Before we know it, you've got another case docket that brings along new suspects. You know, the statements that are on that docket are not the same as the statements that are in this docket. Now you are having a problem.
Now let's talk about there are two teams on this case. So is that helpful?
2 teams how?
Like as in the collection of investigation. So is that a method that could be useful, helpful in making sure that kukho into that any consequences
and maybe the connection of, okay, firstly let's put the general norm, what's going on down there on the ground at the police station. A case docket is opened at the police station and then it's brought to the CIDs, what we call detectives, the normal detectives on the police station level. Then it's investigated. But when the matter does not have result and there is too much pressure on the police to continue investigation, that case docket is drawn, taken out of the police station and be brought to a special investigative unit. I'm not talking about the SIU now. I'm talking about probably the provincial investigators who are dealing with murder and robbery. You know, that specialized unit. So it's not taboo or it's not a wrong thing to shift that case docket from the police station level. But the new investigators must not open a new docket.
Okay.
They must take this very same docket and investigate and put more meat on the bone of the old case docket. The only problem here is that we've got two different dockets.
Yeah.
But being investigated by two teams is not a problem. It cannot compromise the case. It can only strengthen it. But again now, okay, the interesting part I want to come up with, because there are fears, there's questioning, there's a lot of questions. Kelly Khumalo and her attorneys are answering to these allegations.
To the media.
The version, that is not an allegation first. Let's say it's the version of the accused that are sitting behind Advocate Tefo and Mshololo. The version is somebody is going to come here and testify. That witness is not just a witness, it's an eyewitness, meaning that that evidence is not just oral evidence, but a direct evidence. Direct evidence, I mean someone who directly saw what happened.
Okay.
Who testifies, not a hearsay, but a first-hand evidence, will come and say, Kelly Khumalo shot Senzo Meyiwa by mistake. Of course, Sergeant Musia wouldn't comment on that. How would he know it? Because he was not there. He is not that witness. You know what I mean? But that version, he says it to place it on record. Now I'm saying the risk that now the defense is sitting with is that version is there, and that version must be tested by the state, meaning that that witness must eventually come to court and give this evidence.
Mr. Nomvethe.
Yes.
It's been almost what?
8 years.
8 years. You're saying Lamagama Ati Kuko an eyewitness, ezawuthi,
yes,
exclamation marks.
Yeah.
I saw
Yes.
Kelly Khumalo
killing
Senzo
Senzo by mistake.
By mistake. Now, with all the years that the trial iqhuba, the delays, the postponements, the suspensions,
the witnesses there.
Witnesses then. Now, do you
sitting with this information
exactly
without disclosing it?
Do you have faith in the current team that is handling the trial? Uba bangayizisa in flesh le eyewitness sibone. And just before you answer that one, the name calling in court.
No, there's no name calling there.
No. I mean the thingy, the mentioning uba
there's a witness.
Yes.
You know, okay.
Masiqale apho, then let's go to ifate yoba ikhona into ba izokwenzeka lento.
Okay. What would be unprofessional and disingenuous? I don't know how can I put it in simple terms, but stupid. Let's say stupid. Would be calling the name of the witness.
Yeah.
By saying there's a witness that is going to come, you are not putting anyone at risk.
Okay.
Let's start from there.
Okay.
People must just relax. You are not putting anyone at risk. And this witness is not the state witness.
Okay.
Remember, it's the defense witness, not the state witness. I don't know how they got hold of this witness and how did the state miss this witness. Because this witness was supposed to be the state witness, but the state missed it. But I'm saying now there is no risk on that witness because he or she was not called by the name.
Okay.
That's number one.
Yeah.
So no one knows. We just know that there is a witness.
Yeah.
Now I'm saying the risk that the defense team, more especially accused number 1 to 4, is facing is that you don't put a version on record and not follow suit.
That's my
Meaning which you don't say someone is going to come and say,
Yes.
and that person does not come.
Thank you.
So that person must eventually come to court and give evidence. Cross-examination by the state now. Let's say that witness comes and say, yes, I'm the one who saw Senzo Meyiwa being shot by Kelly Khumalo. First question I would ask if I was Baloyi, when did this happen? No, 8 years ago.
Okay.
why did you sit with such a big thing? Firstly, that first question is going to be very hard to ask, Sorman, to answer.
Yeah.
Why did you keep quiet on such an information you're seeing on social media, on the media? We are trying to resolve this matter. You've got the solution. You sit with this information for 8 years. Yeah. Why didn't you come? Then she must answer. I don't know, or he must answer. I don't know what is going to be said, you know, or as to maybe I was afraid or what. I'm not sure. Or I was threatened. I don't know. But that witness must come. If that witness does not come, what Advocate Tefo said that day as a version of his witness is neither here nor there.
Now, true what you're saying. Now, masithi ke ngoku Mr Nomvethe iyafika le eyewitness. Ithi I was there njengobusitsho. And then ayiphendule le question.
Yes.
Stating mhlawumbe sithi bendithreatenishwa. I was paid this amount of money to keep quiet.
Yes.
What should be the next step? Mhlambi sithi ke ngoku uyivumile lento yoba wayekhona. What should be the next step? Should that person be sent to jail, or should that person be of any important use to the state?
You mean the witness?
The witness, yes.
Not the one mentioned by the witness.
No.
No, there's no need to. This person did not lie under oath. Okay. The only thing that you can be investigated and be arrested for is lying under oath.
Yeah.
You see the Batabile Dlamini case.
Yeah.
You say something under oath, and it was not true.
Yeah.
You are guilty of contempt of court.
All right.
Sorry, man. No, not contempt of court. You are guilty of perjury.
Okay.
Because you said something under oath which was not true. But this one did not say anything, but kept quiet. You know what I mean? Now, let's say she reveals or he reveals that, no, I was paid not to say anything.
Okay.
But now I can see that, no, things now are boiling and I must say something. The person that paid her must not just be charged for murder and attempted murder, because there will be attempted murder if you shoot someone when there's people in the room. Maybe possession of stolen firearm, whatever the case may be, but must also be charged for defeating the ends of justice.
All right.
Because when you're trying to conceal evidence and pay people or threaten people not to talk, as a victim of circumstance, you have nothing wrong that you have done. You've just kept quiet because you were paid, or you just kept quiet because you were threatened. There's nothing wrong that you have done.
So uzawuyekwa.
Makayekwe, wenzeni? Akho nto ayenzileyo erongo. Into erongo ayenzileyo is failure to report. But if that was willful, then you can impute that to her or him. But if it was not willful, there was threats and there was money that was paid, you take that payment and that threat, impute it to the person mentioned to have done it, and add a charge of defeating the ends of justice. So let us say now Kelly Kumalo is mentioned and the court accepts that evidence and accepts the reason of delay of this testimony.
Okay.
And that is accepted as evidence that indeed it's Kelly Kumalo who shot this guy and then it was by mistake or whatever the case may be. The police must act once that evidence is admissible and taken into account. Then the police must act now and go and arrest the person that has been mentioned, so that that person can join the accused people and say her piece. There is a notion that is out there, but I know it's a layman's notion that people must prove their innocence. You don't have to prove your innocence in court. The state must prove your guilt beyond reasonable doubt. Right. So you don't have a duty as an accused person to prove your innocence. No, that's not your duty. Your duty is just to say your version of events and bring evidence that, you know, when you look at it, it's proving that I haven't done this.
And that's your only part.
That's your only part. But the person that must prove, okay, let's say now, I agree with people that says prove your innocence. You prove your innocence on what we call preponderance of probability. You don't have a duty to prove your innocence beyond reasonable doubt. The people that have that onus or duty, it's the state.
It's the state.
And the state must prove it without a doubt. You know what I mean? For example, let's not talk about Kelly Kumalo because she's not a suspect. Let's talk about the suspects that are before court, the accused. The state must prove beyond reasonable doubt that accused number 1 participated this way.
Okay.
He was sitting in the car waiting for others to finish up their job. Accused number 2 took the laptop, the phones, the what, and put them in the bag. Accused number 3 shot and killed Senzo Meyiwa. Accused number 4 was checking the coast. Accused number 5, whatever they say, but everybody must have his own
concrete
participation, and that must be proven. Because you will find out there that probably if, let's say, there's anyone guilty, it's accused number 1. And accused number 2 up to 4 up to 5, they are not guilty. They were not even there.
Yeah.
If they can only place accused number 3 because of his firearm on the scene, it's accused number 3 and no one else. So the state has a duty to prove to each and every person that these people were there. They must place them in the crime scene. After placing them in the crime scene, elicit each and everybody's role until they form what they say you are a conspiracy to the murder, and again prove that you acted on common purpose. So we still have a long way to go.
Mr. Nomvethe, let's take a few questions coming through on Facebook. Thank you so much to everyone who has just joined us. We're discussing a trial Orlando Pirates kunye nabafana bafana uSenzo Meyiwa. Uthi uJunior lihle molo apho msasazi nendwende lakho apho kwesitishi esingashishiziyo. Uthi ke uSkhwayiba Ndumiso Masibulele uthi credibility. I think it was a discussion that we had before, Mr. Nomvethe. uJunior lihle uthi tell me something Mhlekazi Nqaba, according to your experience, how long do you think the case will take?
The case will take, that doesn't have anything to do with experience, but it has everything to do with the number of witnesses that will be brought on the stage. Firstly, let me just say, we don't know how many witnesses the state has, you know. It will take more than 5 months, this case. I'm sure about that. Why am I sure? Forget about the state witnesses. We don't know how many are there. They are not disclosed. Talk about 5 accused sitting on the dock. Those 5 accused, each and every person must put his version on the record. He must not just put the version, he must put that version on examination in chief, meaning that the counsels for defense will ask, today we are here because of the case of Senzo Meyiwa. You're one of the accused. On that day, tell us what's going on, what happened. And then he tells us, no, I was shopping, I was in Midrand doing my shopping, I've got an alibi and all that. That person must be cross-examined. So we've got 5 accused that must give their version. Now we're talking about the suspects. There's this anonymous witness, eyewitness, the star witness of the defense team that will come. So it means we've got 6 witnesses for the defense already. It cannot be
less than 5 months.
It cannot be an event. It's going to be a lengthy trial. But what must the court be? I like it. How does the judge sitting managing the postponements? The court must be very careful of long postponements. We don't need long postponements for whatever reason. If it takes us to run this trial every single day, this trial must run every single day until it is finished. Another thing I wanted to talk about is the death of Brigadier. I just forgot his name. There's a state witness that has deposed to a statement or an affidavit who just died. I just forgot his name. The assumption is that that person was killed deliberately and all that. I don't know. He took his pension. He was no longer part of the police. Now, the question I was once asked was, would his evidence be critical? Because the notion or the suspicion is that he was killed because he had critical evidence.
Undlovu. Yes. Enkosi Ziki.
Yes, thank you, Ndlovu. Yeah, Brigadier Ndlovu. He just died now. Now, the suspicion is that Ndlovu would be a star state witness.
Okay.
You know? But Baloyi and his team says, no, Ndlovu was not the star witness. But he was one of the people who went to the scene of crime on that night and monitored these guys that are taking evidence. That witness cannot be the star witness. Why? Because he was not on the ground. He was just in a supervisory role.
Okay.
And again, the court must, one, let's say he deposed to an affidavit that is critical. Baloyi must apply to the court on bar and say, my lord, I've got the affidavit of Brigadier Baloyi, who is now deceased. And this affidavit cannot be accompanied by viva voce evidence, meaning oral evidence, because he's no more. I want to submit this as an exhibit or as evidence. And then he reads that affidavit on record. The defense team will come and oppose that application and say, no, this person is no more. How are we going to cross-examine him? You know, because any evidence that is put on record must be subject to cross-examination.
Okay.
So this is my anticipation. I'm not saying this is going to happen. If Baloyi puts that statement in and say he wants to admit it as evidence, I would vigorously oppose that application.
All right.
Because there must no evidence that is brought to be exhibit on the record that is not tested. You cannot test evidence of somebody that is dead. So I would oppose
anything related to Ndlovu
is
null and void.
It's neither here nor there. If the state attempts to put his evidence as part of the record, it's gonna fail. If it doesn't fail, it will be a new precedence in our jurisprudence, in the South African law, in the South African criminal law, because you can't put evidence that is not going to be tested by the other party.
All right. Another question is coming through from Junior Lihle Uti. What's your take on the company that is, we can say, deprived?
I wouldn't even oppose that application if I was part of the defense team. No,
you're happy with that one?
Okay, look, the gist of this application is that these people are here as part of the, let's say, a newsroom, or what they call it, but the defense and the state is saying, no, these people are not news reporters. They want to do a documentary on the
trial.
Yes. Now, the critical question here is that, do you only allow news rooms or news houses, media houses,
to cover court cases?
Yeah. Two, if it's a documentary, is it not in the interest of the public?
That should have been the discussion.
It is in the interest of the public. That is why I'm saying I wouldn't even oppose that application, because there are cameras in the court already. Adding more cameras doesn't change anything, but giving more access to the public to get exactly what has happened. Now, why oppose that application? I didn't even understand why are they opposing the application. That application should have been just entered freely, but we always want to put a punch before we accept anything. But there was no need to oppose that application. And it was granted, I should think. I should think it was granted because it's in the interest of public. Advocate Tefo is saying these people are trying to make money. They would make money even if they would take clips from
Outside.
E-News or SABC News
Yeah.
and publish what they want to publish. But now that they can have access, the direct access at court, why not? You know? So it was just frivolous that the opposition of that application, it was waste of time, it was frivolous, it shouldn't have been opposed.
Yeah.
It should have been just allowed. It's common cause. We agree. These people must get into court and take what they want to take, because this is in public domain already. Why would you want to deprive other people? I mean, they are a TV channel.
Yeah, the narration of the documentary, I now ba na certain perception,
Deal with, cross that bridge when you get there. How do you know how they are going to present it?
exactly, because that's basically, I think that is
The fears that
yeah.
were there. Look, okay, I know I cut you on this one. You know, I just knew what you are going to ask. Let us say now the court has allowed the what was the name of that thing again? I just forgot it.
Yeah,
but
documentary.
they were that media house. I just forgot its name.
Yeah, no, that's fine.
They are allowed in court. They take the clips that they want to take, and then they go out to the public now and publish a content backed up by live videos that were taken in court on witnesses, and say it either way around. You have a problem, sue the
media
the
house.
media house.
Okay.
Civil, on a civil way. Do not deprive them. Sue them.
Narration yabo of what transpired in court depends on them.
Okay, firstly, what transpired in court, whoever is going to put it in the domain, the public domain, it's not going to change. It was what was said. The only problem would be the interpretation to put it on your newspaper, of which SABC can do the same mistake and misinterpret facts. You know what I mean? So sue the newspaper after publishing the documentary, and not deprive them of their right to what you call this, to journalism and public speaking and all those things.
Let's go into Masedi JR Mafilika. Uti, is Detective Mosia credible if one can judge about his contradictory responses and lack of skills and refusal to answer some of the questions before? No comment allowed in the court of law.
Cool.
Allowed?
Yes.
In what basis, Mr. Nomvethe?
When you take oath before you give testimony in court, you say, what I'm going to say here is truth.
Yeah.
Nothing else but the truth and all the truth.
Yeah.
Help me, God. There you must tell the truth. That's number one.
Yeah.
Number two, over and above telling the truth,
yes,
what you are not sure about, say it.
Okay.
What you cannot, okay. You are asking a question. Is no comment to that question allowed in court?
Yes.
Yes. The answer to that question is yes.
Okay.
Because you don't have to say things that you don't know. That's number one.
All right.
You don't have to lie and fabricate evidence. We are very much careful of a fabricated evidence.
Okay.
So, let me just make an example. Advocate Tefo says, there's someone who is going to come. Let me just put the one that's known by everybody. Someone is going to come and say Senzo was shot by Kilikum. How would he know that? He wouldn't know. If he was not allowed to say, I cannot comment to that, it would mean that he's forced to say something that he doesn't know. So it is allowed. You just say, no, I don't know this thing, no comment, I will not. You can even say, I refuse to answer that question. That is not admission. When you say you refuse to answer a question in court, it doesn't mean you are admitting. You are not saying yes or you are not saying no. You are just distancing yourself from the question because you don't bear the direct facts of what has been asked on you. So he is right. Credibility. I wouldn't say Mr. Mosia is not credible. But I would just say Mr. Mosia has a problem of dealing with the after effect of a crime scene.
Okay.
and he had a problem of collecting evidence later that has been contaminated. And he has a problem of having evidence that did not stand the cross-examination. Do you get my point? So saying he is not credible, he is a credible witness as far as I can judge him. And there's something that is called in court the demeanor. The demeanor is how you present your case. His demeanor is fine. He's not afraid. He's not trying to, I can say he's trying to add up things and separate things. When he doesn't know something, he says, I don't know. So he's a credible witness. But he can be a poor witness in respect of what happened in the scene of crime, because a lot of wrong things happened.
All right. Let's go into Junior Lihle with another question. Enkosi Junior, Enkosi Xolsani enzokuhle endleleni. Uthi, I have a question now of Advocate Teff's arrest. Is there any law which protects him from the way he was arrested?
He was badly arrested. I wrote about that on Facebook. The BLA, which is the Black Lawyers Association, wrote about that and put a statement on. The manner at which he was arrested was very bad. It was degrading. It was undignified. It was not professional. He can sue the state for unlawful arrest, or I'm not sure. He was detained. I think he sat one night. And then he got bail in court because he was upon a warrant of arrest. So you can't get bail on a warrant of arrest. You must go to the court and explain why were you not in court. But what I cannot comment on is whether or not his warrant of arrest was legit. Because there is a suspicion that says his warrant of arrest was not legit. His comments, because I listened to him when he commented after he was released, he said that case was finalized. He wrote representations, and then the representations were accepted by the DPP, and then the charges were withdrawn. Now, I'm not sure how does that happen. When charges are withdrawn, you get a warrant for your arrest on the same case. I'm not sure. I'm not going to comment on that because I am not sure as to why he was arrested. Allegations are saying he was arrested for a contempt of court case, and then he did not attend court. I don't have much to say on that. But I can say you don't handcuff a suspect that does not resist your arrest. They could have waited until trial is finished that day, and then when he comes out of court, they ask him nicely, counsel, we've got this warrant of arrest. It's not that's favorism. It's not favorism.
I was going to ask you that.
It's just dignity.
I was going to ask you if it's not going to be.
No, it's not favorism. It must happen to you as well. In your classroom. If you are a varsity student, there's allegations on you, and the police come into your classroom when there's everybody watching you. They must not parade you as a dangerous criminal and all that whilst you don't resist their arrest. They should just, talk to your lecturer. We are looking for Manez. They take you nicely, get you outside, get your things, but we have a warrant for your arrest.
So, just a quick one.
So it was wrong.
So you are forced to handcuffs when you resist arrest.
When you resist arrest. You don't have to be handcuffed.
Thank you so much for that information.
And if people... Okay.
We need to know that.
Yes.
We need to know that.
If you are not resisting... Okay. What is handcuffs for? Handcuffs is a minimum force that is applied by the police in terms of Section 49, subsection 1 of the Criminal Procedure Act when you resist your arrest. Or resist... Like, for example, police wants to arrest you, you draw a knife. They can shoot you. They can beat you with a donkey pill. They can pepper spray you. They must use minimum force that is equivalent to your resistance. Do you know what I mean?
If it's a gun, there must be
If it's a gun. If it's a knife, pepper spray, maybe a baton, and they kick you, or whatever the case may be. Or if it's a knife...
They have to arrest you.
If it's a knife and you are dangerous, they can even shoot you. But what I'm saying is that the force used must be appropriate and it must be aligned with the level of resistance.
Yeah, resistance,
There was
okay.
no resistance there. Another thing that was wrong about that arrest, I don't want, let me emphasize this because it's important. When one is arresting you, you come and say, I am Detective Nqaba Nomvethe from Cambridge Police Station in East London. I have a warrant for your arrest. I'm arresting you for theft.
Okay.
From now on, you are under arrest without even touching you. That detective did not say that. He said, there's a warrant of your arrest. And then he said, what is this? He said, no, let's talk in the police station. That's not how you arrest people.
His rights were not explained
His rights were
to
not
him.
explained to him. The instructing attorney for Advocate Tefo asked this gentleman, why are you not reading him his rights publicly? And he said, no, I'm not going to read any rights. He must just, we're going to talk in the station. You don't do that at the point of arrest. At the point of arrest, you know what we see on TV, that you have a right to remain silent,
Anything
whatever
you say can be used to-
That is not a joke. It must happen. It must happen. Every policeman has got what we call a pocket book. Those rights are written in the first page of the pocket book. If he doesn't know them, he must open his pocket book and read them. Say, I'm arresting you for theft. I'm Nqaba Nomvethe. I'm a police official. I've got a warrant for your arrest.
Yeah.
You did not attend court on the 28th of December 2021, you know, on charges of contempt of court or theft or whatever the case may be. So I'm now arresting you. Then if you resist, then they can handcuff you and use minimum force.
Yeah. There's another question from, in fact, it's a statement from Pamela Lambi Sambaimbai. Uti, but the lawyers are lying and changing the truth to be false, vice versa. Uti, something fishy about this case, but the truth will come out. Yeah, Uti, umasele junior mafilika ena. I have been arrested many times, and at one point I had to drive my own car from one police station to the next, following police to be detained. In all cases, I was not handcuffed.
That's dignity.
That's dignity. That's
dignity. And he was successfully arrested whilst he was driving his own car. Yeah, he knows. He was under arrest. You know what I mean?
Yeah.
Yes, the police have a right to touch you and arrest you if you resist arrest.
Yeah.
But if you don't, there was no point. I mean, that guy was in cameras. He wouldn't run away in front of everybody. So it's really, and I'm not going to comment on the liars and the lawyers and the liars.
Changing Inyani to
I don't know about that. The lawyers and the liars.
We're sitting on 12 after 5. If you just joined us, welcome to the final whistle with Manez. In studio, we have Mr Nqaba Nomvethe. Ukhona apha studio sincokola ngetrial wayisakuba kunozinto Orlando Pirates kunye nabafana uSenzo Meyiwa u2 Junior yena. Concerning the case again, what will happen now to the 5 men when the case finish and it's discovered they have nothing to do with the accused of
with the murder.
Okay.
Yeah.
Yeah.
They have nothing to do with this crime.
Yeah.
They will be acquitted. When you sit for trial, there's 2 things that must happen. You must be found guilty beyond reasonable doubt.
Sure.
Failing which, you must be acquitted. So they will be acquitted. It's up to them if they go back and sue the state for unlawful arrest, unlawful detention, and malprosecution. It's up to them, but they will cross that bridge when they get there.
Okay.
But again, you know, they can be found not guilty, meaning acquitted. They can even be acquitted in terms of Section 174. There is a section that is called Section 174. 174 of the Criminal Procedure Act says if the state opens its case, bring witnesses on board. Those witnesses are cross-examined, and there is nothing linking these suspects into what is said here. Then that people can apply for a discharge in terms of Section 174.
Yeah.
And they get scot-free, you know, and this can happen here.
Ngokomthetho akho nto yoba umthetho xa ukubambe wrongo ngokwawo without you suing anything. Because we did this wrongfully, this is what we're going to give you.
The Minister of Police always failed to do that, unfortunately.
Because
You must pay
observation yam, ne?
Yes.
Wouldn't that be saving
A lot of legal costs.
Legal costs, because you know when you go and say I want to sue the state for unlawful arrest okanye for whatever case onoyibeka etafileni,
legal costs,
kuzoyiwe court
time.
You will have a magwetha. Why umthetho ungavela uthi Manez no khange uyiqhekeze man le radio ungene kakuhle pha.
We are sorry.
We are sorry.
We are offering
Nansi 1.7 million.
Yeah.
This is our apology from for ukwenza lendo. And then that's it. I move on with my life.
The state will resist you to the core, even if you have even issued that civil claim. They will resist you. Not here in South Africa. You can get that in America or elsewhere, you know, but not here. Not here. Look at the case of this guy that was stepped by the police on his neck.
Yeah.
He said he can't breathe in the United States of America.
The rugby guy.
He didn't go to court. He was just compensated, the family. Remember, he died.
Yeah.
His funeral was a state funeral. The people that were wrong were disciplined, chased out of work, and he was compensated without struggle.
Now,
but not here. Here in South Africa, you will have to struggle, my friend. I'm telling you, you will have to struggle.
Yeah.
You know.
Now let's talk about the time. Now there's been concerns about the councils having a meeting during a trial, okanye spending a lot of time without any update. Abantu belindile, and the councils were just in a room talking non-stop. There's been that. Should that be into ebekufanele ba thina as the general public siyiqhele, that kwi trial kubakho izinto ezibanjalo, into yokuba the entire bayovalelana phaa kwi chamber, and there's like a lot of time that is spent there, no update, none whatsoever that comes to us?
In a matter of fact, we must thank them for that time.
Is it?
Why?
Educate me on that one, Mr.
Why
Nomvethe.
am I saying?
Yeah.
Defense and the prosecution and the judge go to chambers. There we talk issues that are non-peculiar and issues that are peculiar. So when you come out of that chamber, we know what to argue about and what not to argue about. Okay. For example, issues of common cause. We go there. Are you going to raise this? Are you still interested in raising this? For example, let's say, what can I think of? Or a charge sheet. Let's say a charge sheet. I'm complaining that this indictment is not up to standard. My client cannot be charged for recklessly driving a motor vehicle, but we are answering to murder. Remove this thing.
Okay.
We discuss those things in chambers. This is not necessary for us to waste time in court and argue. Then we agree, no, we are no longer pursuing this issue, you know. So when we get to court, we know exactly what we want to achieve.
So if it rises
that
again?
It cannot rise.
Rise.
If it rises again, you will be reminded of the chamber meeting.
It will be dismissed.
Manez, we said you're not raising that. Why are you raising it? You know, off record, we said you don't raise that. So don't waste our time. What's the relevance? Then it will be chucked off so quickly. If that time is not spent there, you will sit at court arguing a charge that was not supposed to be there for 2 hours.
So that
instead of getting into the gist of the bone of contention.
So the chamber was necessary.
Chamber is always necessary.
Okay.
Because it will happen tomorrow. So don't cry when they are in chambers. When they are in chambers, they are working on what is necessary and what is not necessary for today's trial.
Yeah.
For example, let me just make an example. I'm not going to make it a Senzo Meyiwa case example. Just another example.
Yeah.
I have a witness that was, I've got a driver I'm owning a taxi and my driver is hit by a car there. And then I have a statement as an owner of the taxi, but I was not there.
Yeah.
And then there is a statement for the driver and the passengers that were there. We are on a trial. Now, what is my evidence going to add value there? There's no value except for saying this is my car. If nobody disputes that this car belongs to me, why do we have to argue that in court? So in the chamber, we're saying we're not going to call Mr. Nomvethe because there's no one who is disputing that the car doesn't belong to the driver. You know? So there's no point to pursue this issue. So leave it out. We agree there. When we go there, we have eliminated one unnecessary witness. That would waste 3 hours of our time. So that chamber meeting is important.
It's basically to tackle all those issues.
Unnecessary issues, necessary issues, what we're going to talk about, the time that we're going to spend in court today, and who is coming to the dock, how many witnesses, you know, and then we take it from there.
Yeah, we're sitting on 20 minutes of radio. We're giving you the final whistle with Manez. Mr. Nomvethe, now with the witnesses, if you are cooler, do we wait?
Yeah, take another one.
We take another one.
Yeah, take another one until that one recovers. But the death, I almost said the death certificate. Medical certificate, sorry,
must be presented.
Yeah.
Okay.
You can't say you are cooler and you don't just pitch in court.
You don't have.
When you say you are cooler, give us something that proves. Then we skip you, we take another witness. You are never late. I mean, you know, unless you are the only witness. If you are the only witness, then we must wait until we postpone for your health to recover, you know.
Yeah.
But if there's more witnesses to be called, call someone else. Skip that one.
Yeah. We talked about the dockets. We talked about the witnesses. We talked about the credibility. We talked about the information that keeps on rising with regards to the trial.
And the consequence management.
And the consequence management of whatever that is unfolding, trial, Senzo. The time now, the time frame of the entire trial is something that you mentioned, you know, this might take approximately
5 months.
5 to 6 months. So now, in your prediction,
yes,
who is it going to be in favor of?
No, I can't tell.
In your prediction,
look, you can't predict anything now.
Yeah.
Until you hear both sides of the story. You know, there's this mistake that people do, and even lawyers are even guilty of this offense. You can't predict a case where you only have one side of the coin. Even if you have both sides of the coin, it's still difficult to say guilty or not guilty. Remember, this is a criminal trial. It's not a civil trial where payment was not made. A contract was concluded, payment is not made. That is clear. If I've got a contract, I do your job, I deliver on my part, you don't deliver, you will lose. But here, it's a criminal trial. You wouldn't know who will say what. For example, now we are threatened of a witness that will come and mention Kelly Khumalo as a killer. Maybe the state has got another name or something else. How would we know? How would you predict? Still early ages. Still early ages.
Are the defense attorneys doing well?
So far. My complaint would only be the approach on the part of Advocate Tefo. He acts like he knows a lot of facts about
what happened on the crime scene.
Yes, it acts as if he was there. Otherwise, that's what I was meaning when I said he was not much clinical about it. That impartiality as an attorney or a defense lawyer, you exercise that. You just try to put evidence on record. You don't place yourself as if you are one of the, eyewitnesses or people that were there. But I cannot talk bad. He's a very good counsel, except for that. When you know something that other people don't know, Yeah, that is how I judge him.
Yeah.
He knows a lot that we don't know.
There's a comment from Junior, Mr. Nomvethe. I think it will need the other viewers, yourself and myself, and everyone who's watching to confirm and agree that what he's saying is actually what transpired. Uti, among the 7 people whom were in the house, there are 2 children. Does their word count in this case? I mean, to explain what happened. Would it be tangible to draw them along and say, tell us what you saw?
It's necessary. It's so necessary. It's so necessary even in the absence of this allegation that Kelly killed. Let's say with the version that we only know is the robbers, version.
Housebreaking.
Still, they are even if they can talk, then we still need them. Because 7 people who are saying the same thing can decide the case one way or the other. 7 people whom 4 will contradict the 3 can put the case in another position.
Yeah.
So they must talk.
You're saying the age doesn't matter as long as they're in a good state of answering all these questions.
A competent witness is a witness that is over the age of 16 years.
Thank you. Let's start there.
That is a competent witness.
Yeah.
But on rape cases, murder cases, even a child of 8 years can be taken to court, but an intermediary must be used. There's someone who's called an intermediary, a social worker that elicits evidence out of a child, but in a
someone who's going to be
child-friendly manner.
Who's going to accommodate the proceedings.
Yes.
Yeah,
it's on the screen. The child is not even in court.
Oh, yeah.
She's playing with his toys and all that. And then the court asks questions through the intermediary. The child does not even hear what is being asked. And then the intermediary will say, that day, tell me, and then what happened? No, that is evidence. It's related to court. But the way you take it, it must be child friendly. It must be taken lawfully, regardless of the age. That's my answer to that question.
Junior,
age does not talk.
Junior, Pamela wants to know how old were they at the time. I think it would also add value to what we're talking about. Babebanga 2014, because even if we can have that mechanism, yokufumana evidence of what transpired, the age yabo will matter.
It's an advantage that now they are older.
Okay.
If the state, I'm talking about investigation, took statements from them at that time.
Okay.
Let's say statements were taken. You know, in rape cases, a child is raped. You don't sit and not take a statement of that child since a child.
Yeah.
You take the statement. So if statements were taken in 2014, and now they are now 21 years, that's a cherry on top.
Okay.
They know exactly what they wrote there. They know exactly what happened.
It has a question from Uziki Machangaza. Uti documentary. They mentioned that Kelly did not allow her kid to be questioned. Wasn't that defeating the ends of justice?
It's documentary.
So that we overrule that one.
It's not evidence.
It's not evidence. It's documentary. I think, Ezeki, you got the answer, because I was also under the impression that is why I was asking Mr. Nomvethe that it documentary what contribution will it have to the public? Because now what Ziki is coming with now, and something I fumene good documentary relating to the same trial that we are talking about here.
What I like is that okay, the mistake that has been done by the 161 or whoever had that documentary is making a documentary, is putting the cart before the horse. It's making the documentary before the proceedings commenced.
I think that's the submission.
The best was the documentary that was made of Oscar Pistorius after the case was made. Because documentaries are nothing but speculations. It's speculation.
Okay, so now...
Do you know what I mean? But again, now, if you make a documentary after you got the facts from the court and say, this is a probability, this is what was said. No one was in the house when Oscar Pistorius killed River Steenkamp. But the documentary, after they have heard the evidence, now it was more probably. How do you do a documentary of a speculation without even hearing one witness? So I cannot answer that question because it's a documentary. It's not evidence. It was not factual. It was speculation.
Yeah. All right.
I think we've covered a lot of ground.
We've covered a lot, Mr. Nomvethe. We've covered a lot, but I think I will still need more clarity on the dockets, though, and because with whatever that is going on, I asked you a question in Dubai. The defense attorneys are there, doing a great job, and you said, as far as the trial is
so
concerned,
far they are doing good.
You're comfortable with?
I'm happy. No, I'm happy so far.
Yeah.
Less these small issues. No, there are small issues, procedural issues, but the quality of
the trial,
eliciting of evidence is of good quality.
Yeah.
I cannot, and I even give much credit to the lady,
Mshololo.
Mshololo is very clinical.
On the cross-examination.
On the cross-examination, she comes up with some nuggets that are very on point, and you know, I'm giving that to her. She is good.
My biggest fear that I think maybe nezinye South Africans have is this thing of using the so-called trials to sort of humiliate or question certain professions. Umzekelo, with this thing yoba kuthiwe umzekelo the surgeon has been like mocked on social media, and Londo came to the umbrella, the South African Police Service, to say, guys, are you aware of your mandate? Now understand umsebenzi wenu.
Yeah.
Now you're saying we cannot predict what will transpire when the stakes have changed with regards to the trial. We don't know what is going to happen when kusitwa now it's your time.
Yes.
Siqelele sakho story. What is it? What happened? And now, do you think ingalo yomthetho masibeke ecaleni the attorneys, and then let's talk about the first handers of yonke lendo, the people who confirmed that Senzo has passed on ngelixesha and ndondondondon apha endaweni ethile mnali tyala livuliwe, bona basahamba kakuhle, which is the SAPS? Are they still, in terms of ukudibanisa what is needed by the trial?
You know, it's I'm blaming the SAPS. I think you can hear me. I'm always blaming them. I want to blame SAPS in all regard. The reason why this case took so long to go to trial is because of SAPS.
Okay.
That is the truth of the matter.
Let me give you time to dwell on that.
It's because of SAPS. Why am I saying so? SAPS should have gathered evidence on the day of, okay, firstly, they should have gone to that scene earlier,
okay,
or sooner than later. That's number one. Can we blame them for their late reaction on that? No.
Okay.
Why? Senzo might have died now, and then the people that are in the house don't call the police immediately.
Okay.
What are you expecting of the police? To arrive late? For whatever reason. For whatever reason. If the police were called immediately and arrived at the scene immediately, we could have having a better case to go through.
Yeah.
But now you cannot applaud the police because they were late, but they will put an excuse and say, no, we were not late. We were called after 4 hours.
Okay.
So we were not even aware that there is matter that is happening until 4 hours gone past. So how do you blame them? So what I blame them of is that at the time they were in the scene of crime, they could have managed it better. And they failed to do that. A lot of training is needed, more especially in those people called these people forensic investigators. You know, the local criminal record center that is called LCRC in the police must be trained so hard so that they don't leave any stone unturned on the scene of crime. They left a lot of evidence untapped there.
You're saying, Mr. Nomvethe, they arrived late. That might be due to them receiving the call late.
The
non-reporting, you say. And also that when they arrived, they left, okanye, they did not pay thorough attention to
some of important evidence
that could have helped to wrap up the case
including searching the people that were there. Trying to find out if there is no firearm in that house.
With the people now,
that were there. Including separating those people and interrogating them one by one.
To find
contradictions, if any.
Yeah.
To find, corroborations,
because
if any.
Everyone at that time
has got his own version.
Yeah.
Everybody is like,
should have been edgy at the time.
Yes, and you will see who is telling the truth and who is lying. So the police failed us in the scene of crime. I will not compromise that. The police failed Senzo Meyiwa in the now we are working on circumstantial evidence. I'm not sure about this eyewitness now because it's going to be direct evidence. But as far as the state is concerned,
do you trust that? Do you trust that
if
that
this person is going to come?
Yeah.
I don't know. We depend on the defense when that time comes. But as far as the state is concerned, they are depending on a very scanty, thin evidence that could compromise this case.
Yeah.
Why? Because the crime scene has been failed by the police.
Good trials, Mr. Nomvethe. Kubakho it's becoming a norm lately in South Africa, the changing of judges. Uthi ujunior phaya, should the current judge get sick, uyalindwa imiswe okanye
we can't.
Ukhangelwe enye judge.
We must wait for him until he dies or he recovers.
In what stage?
Why?
Okay.
Because once a matter is a partly heard, we call it a partly heard. Now, the Senzo Meyiwa matter is a partly heard. It means it has been heard partly by a certain judge. And then now we will struggle if we are going to say, let's not wait.
Okay.
Because let me just tell you about the case of Tim Omotoso, the pastor that I want to talk about these cases that attract people's attention. Tim Omotoso that trial started before Judge.
I just forgot the name.
I just forgot his name.
Yeah.
But it appeared before him. It proceeded. And the defense applied for his recusal.
Yeah.
Because one of the witnesses slept in the B&B that was owned by the wife of the judge. Now I think it's Judge Zilwa that is running the case. The matter had to start de novo meaning that it had to start as if it was never there. So when you take a matter to another judge, no judge must sit for a partly heard matter for another judge. Mistakes will happen.
So it must start over.
Start over.
So the information that was heard must be unheard.
Must be as if it was never there, and we start over again. So that could be a big delay if we can have this judge out of the bench for whatever reason.
Yeah.
Maybe he dies or he is recused, then we will have a problem.
So
we'll start over again.
Yeah. So a recusal must be on those bases.
Must be on what we call bias. I mean, you must prove it. You can't just say, I must recuse myself for no reason. It must be a valid reason. Why should I recuse myself from the instance? Give a valid reason, and that reason, make it a point that it stands the test of time.
Yeah.
There is a lot. Jacob Zuma is trying to remove Billy Downer as a prosecutor. He failed up until the Supreme Court of Appeals. You know, he's going to fail even in the Constitutional Court. You know what I mean? So it depends. What are your reasons for the removal?
Okay.
If they are not, they don't hold water, then no one is going to recuse himself. Mr. Mkolo is trying to remove Judge Stretch on the case here in Bishop, on the Nelson Mandela
the
saga. He failed. He's going now to the Supreme Court of Appeals. No. He failed. High Court Bishop. He went to the Supreme Court of Appeals. He failed. From the Supreme Court of Appeals, he's now going to the Constitutional Court.
Yeah.
Now,
so it must be something that
holds water.
Okay.
A clear bias. A clear conflict of interest.
Yeah.
Yes.
Okay. Now with Lena trial, Mr. Nomvethe, you're saying the proceedings are still
very pure,
running well.
The
up
judge
to this
is
far.
controlling his court nicely. Everybody is playing their role.
Yeah. Any predictions of what could happen when things turn around?
Like what?
When the so-called eyewitness does not appear.
No. If the so-called eyewitness does not appear, what the advocate Tefo said is moot. He didn't say anything. He lied in court.
And nothing will be done.
I'm not sure about what the state is going to do, because they could say, no, we do have a witness, but there's a change of heart on the witness. He doesn't want to come. You can't say they are lying, because you must prove that indeed this witness doesn't want to come. Sorry, man, indeed this witness was never there in the first place. But if they say, no, the witness is there, but he's afraid, he doesn't want to come and testify.
There are threats.
Or we want this witness on witness protection program. Then this witness testifies away from the court because he can die. So there's a lot that can happen here. But I cannot predict anything now.
Yeah.
Because we don't know whether or not these witnesses are there. Yeah. Until such time they are needed. Then we will say the prediction here is that, okay, the witness was supposed to be here. He is not here. It means the probability is that he was never there.
Yeah.
If he was there, he's threatened. If he's threatened, the state must play its role and help the defense to protect that witness so that, the truth can unveil itself. So no predictions. You can't predict anything. It's still early ages.
Yeah.
But I'm telling you, once the defense case is opened, after once Section 174 is refused, if they will apply for it, then we will have now the clear picture as to where things are going. We will tell you that, okay, this is the direction we are taking now.
Okay. Advocate Tefo said accused 1 and 2 are placed in isolation in prison. What's your take on that? They need to see their family Kaloku is in prison wrong in doing that. In isolation isn't something. Is it something that is fair?
Once you get arrested, you become the property of the state. They decide where to take you, where to place you. But what the prison cannot do is to deprive you visits by your family. Whether you are in isolation or you are in maximum, your family will have time to visit you. But we cannot say now, now that you are isolated, that is wrong. And the court does not have jurisdiction in commanding the prisons as to what to do with their prisoners.
Right.
They know the risk, they are working there, they know what must happen to their prisoners, and nobody else must interfere on that. Even the courts cannot interfere.
Right.
What must happen is that if he feels like there's that problem, he must write to the commander of the prison and say, look, there's these conditions, why? Get explanation, and then he works on that. He cannot just make that allegation and say this person must be released and be amongst other people. If he's in isolation or solitary confinement, he must be placed there by the prisoner, by the prison authorities, because he now belongs to the state.
All right.
He is a property of the correctional center.
All right, one last question before ndithi Jep kwezinye zemidlalo. Mr Nomvethe uthi unomfundo Madinda, and now what is going to happen about the information from Mr Ndlovu who have passed on? You touched on that.
No, it's I cannot allow that to happen. If I was Tefo, I would vigorously argue that his evidence, no matter how good it was, it must be just struck off record. We can't have evidence that cannot be challenged by cross-examination. So Brigadier Ndlovu is like he was never there.
Yeah. Another follow-up question from Unomfundo Madinda uti, and why did they not bring the original of fingerprints from the onset and waited for the lawyer to ask for them? All these delaying tactics, Mr. Nomvethe, what could have been
I'm still
the basis?
blaming
SAPS.
Blaming. SAPS has been very poor in this investigation, my friend. It's just a pity. I don't know how can I re-emphasize and explain this. It's a pity SAPS failed to do its job here.
Thoroughly.
Yes.
Yeah.
And I'm not going to tap into the battle between Begicele and this advocate Tefo. You know, he made some comments that I was so shocked of. But SAPS failed this investigation. I will say it again, they failed.
All right. We're sitting on 13 minutes before insimbi yesithandathu phambi koba sibe kanti siyayiqukumbela siyivale inkqubo yethu. Masikujongele iziphumo zemidlalo ye-Africa Cup of Nation qualifiers. Sijonge into yokuba kuqhutye kwenjani na. We're just going to give Mr Nomvethe a breather before we conclude the show namhlanje. Then sibe kanti ke we wrap up with everything that has happened. Sikujongele kuqala imidlalo eqhubayo into yoba kumiwe njani na kweliya icala. iNamibia inkqenkqeza phambili ngenxa kwelinye iqubisana neBurundi, lo umdlalo udlalelwa apha eMzantsi Afrika. Sikujongele ke neziphumo zemidlalo phaa kwi-Africa Cup of Nation, into yokuba kuqhutywa njani na. Amaqela kamaninzi sele eyifumene impumelelo, amaqela amaninzi sele ebethiwe phaa kwi-AFCON ngelishwa ke lethu iqela phaa loMzantsi Afrika. No to be found, because ukuqualifya it's something engakhange bekanti ke iyapopa. Besitshilo ke sathi ngoku inqaku linye ngapha kweBurundi nakwiNamibia. It's a draw phakathi kweBurundi kunye neNamibia. Sele uphelile lo umdlalo ngolwesihlanu umhla wesithathu kuJune. iBurkina Faso izibethele iCape Verde ngamanqaku amabini kwelingekhoyo. iCote d'Ivoire yazibethela iZambia. iChipolopolo ngamanqaku amathathu kwelinye. iTogo yabamba nentanganye neSwatini ngamanqaku amabini macala. iComoros izibethele iLesotho ngamanqaku amabini kwelingekhoyo. ngolwesine umhla wesibini kuJune iTunisia ithi yabakanti ke yaphumelela ibetha iEquatorial Guinea ngamanqaku amane kwelingekhoyo. Mozambique yabamba nentanganye neRwanda ngenqaku elinye macala. ngolwesithathu umhla wokuqala kuJune iGhana fumene impumelelo yayo izibethela iMadagascar ngamanqaku amathathu kwelingekhoyo. iLibya yazibethela iBotswana ngo-1-0. iAngola yazibethela iCentral African Republic ngamanqaku amabini kwelinye. nge-29th lwesibini iGambia xebe idlala entanganye neChad ngamanqaku amabini macala. iBotswana abekanti ke lo umdlalo uyamiswa. Masikujongele ke nezinye izinto ebezisenzeka apha kwezemidlalo. Masijonge ngoku imidlalo ezabakanti ke iba khona phaa kwi-AFCON. Okay, masikujongele phaa kwi-Champions League. Siyavuyisana ke neqela loMzantsi Afrika Mamelodi Sundowns abathe bazifumanela impumelelo yabo ke. In fact bethe iqela iqela le-White Athletic. Mamelodi Sundowns isematheni kaloku ngoba iphumelela yonke into ephambi kwayo. PSL yale season ithi yaba kanti ke yayithatha bethiwe uPitso Msimane ke liqela neqela lakhe Al ngamanqaku amabini ngomvulo i30th nalapho ke yathe kushiyeke iminyaka engamashumi amahlanu kuba ibe kanti i-CAF okanye ibhola yalapha eAfrika iyafana ne-UEFA Champions League uthi ngokwestandard nokwendlela kwenziwa ngayo sisephuwa kakhulu okanye sisengasemva thina si-continent ye-Afrika. Ngolwesithathu i-PSL playoffs sisolo sitheba kanti ke zifumanele impumelelo yayo izibethela i-Cape Town All Stars ngomvulo i-Cape Town All Stars ke yona nge-29th yabe kanti ke ibethiwe ku-University of Pretoria ama-Tuks ngamanqaku amathathu. Kwelinye masijonge ke ngoku into yokuba ithini na into phaa kwezinye ke izinto zemidlalo imazwi ayaphoka phaa kwiqakamba kwi-cricket yalapha eMzantsi Afrika ethaba kanti ke iba i-victim ye-violence uMondli Khumalo. He was brutally attacked ngapha e-UK. Abantu bomZantsi Afrika basothukile ke iloo nto besithi hayi noko ithe gqolo into yokuba sports people from South Africa gets attacked kumazwe aphesheya besithi noko bayixhasi ke le nto. Lo mfo ngapha emlazi neminyaka amashumi amabini ubeyile ke kwela cala njenge-fast bowler yomZantsi Afrika endwendwele kwela cala kodwa ke kwatsho ke into yokubana uthe xa ifike erenkini phaya kwanzima kakhulu njengoba engumdlali wela qela eNorth Pattern Cricket Club udlala phayana ke as a overseas professional batsho abantu besithi bengumuntu nje ongumuntu ofikelelekayo ebantwini khange bayicingele into yokuba kungenzeka izinto ezinje. Asaphuma ke amazwi bathi abantu noko makuncediswe usapho lwakhe lukwazi ukuyombona esibhedlela nanjengokuba zivelile ingxelo zokuba uchacha kuhle kwela cala. Momentum Proteas suffered defeat ke kwi-opening T20 ngapha Ireland. Ucaptain we-Ireland uGaby Lewis uthi wakhokela phambili kwiqela lakhe ukuze libe kanti liyakwazi ukubetha amakhwenkwe oMzantsi Afrika kulono ke umdlalo njengokuba umqeqeshi uHilton Mohreng etshilo wathi baliqole baligangatha bakulungiselele into yokuba bayakwazi ukuyodlala ke kulona umdlalo. Uqela leCheetahs kuthiwe kuba kanti lifumana indaba ezimnandi lokuyodlala ke eEurope kule season izayo. eSerabhu waqinisekisa ke European Professional Clubs Rugby i-EPCR knockout competition izabe iquka ke iqela eli le Cheetahs kanti ke ne-financial strains zezinye ke izinto ezithethwayo okanye zezinye zezinto eziveziweyo kosompempe abamnyama phaa kumbhoxo kuthiwa noko bayakhalaza kakhulu phaa eGauteng bathi osompempe abamnyama imali abayamkelayo ayixolisi kakhulu. Iqela lamabhokobhoko liqalile kuzilungiselela kwimidlalo walo vavanyo kunye neWales kwiCastle Laka incoming series ezawingapha ke ePretoria eBloemfontein kunye naseKapa ngoJuly. Ezi-franchise ezintathu ke zizabe zijamelana ke phaa kwi-quarter finals nalapho uJack Snemba uthe uzawubhengeza khona ke kule nyanga siya kuyo into yokuba kuzabe ingobani na amakhwenkwe aze kube elapho ngobani amakhwenkwe aza kube ejamelana ke kulona umdlalo. Stellenbosch coach Steve Barker, Cape Town City goalkeeper Hugo Marcus bathe babhengezwa ke njengebona abadlali okanye ke abantu abaqeqeshi abathe batshotshentla kwi-PSL nanjengokuba besele ivalwa ke i-season ngabo ke abathe babakanti ke bafumana ezimbasa zilandelelanayo. U-technical sporting technical director Kaizer Chiefs uKaizer Mdaung Jr uthi akazukuphazanyiswa uArthur Zwane kunye noDelon Shepherd kwizicwangciso zakhe kweli qela nanjengoba iKaizer Chiefs yaqinisekisa into yokuba uArthur Zwane 10-1 nguye oza kuxuzula imikhala kweli qela. Amakhosi akhulu uStuart Baxter emveni kokuba ethe noko akayifumana impumelelo emveni kokuba ethe wabuyela kweli qela lase-Natural. Amakhosi akhululeyo abadlali abaluthotho emveni kokuba noko lithe laba kanti ligqiba iminyaka emininzi lingayifumani impumelelo. Kodwa ke kwafunyanwa ke into yokuba makukhangelwe into yoba ngomphi umphini ozawuxozwa ukuze ibe kanti iyafumaneka impumelelo kweli qela le-Kaizer Chiefs. Kanti ke bafana yona kuzafuneka ibe kanti ikhangela omnye umphini ke ngoku nanjengokuba uRashid Terok kunye noSiyanda Xule engazi kubakho kumdlalo we-World Cup qualifiers. Uyakhumbula ke lokho into yokuba eliqela lizawuqubisana neMorocco ngoku kuthiwa kuzafuneka ibe khona indlela ephucukileyo abazofuneka beyizamile njengoba kungazubakho lamakhwenkwe amabini phaa ngasemva. Luvuyo Memela uthusiwe ukukhululwa kwakhe iqela lamaZulu emveni kweminyaka eli-10 kweliqela. Amaqela ke yaKwaZulu Natal athe gqolo ekukhululeni abadlali abangaphaya kwe-15 players now that have been released. So naye ke uthi uthukile bese nethemba lokuba uzawuqhubekeka ehlala kweliqela. Siphompulu uzibandakanye neqela leMamelodi Sundowns ngemali ke engakhange ivezwe into yokuba yimalini na athe wabakanti uthengwa ngayo leqela eli leMamelodi Sundowns. Bekukho amahle ke ukuba angangena kwiqela eli le-Kaizer Chiefs. Phinde sibuyele kwi-national team Bafana medical team ithi noko akukho injury, akukho monzakalo sinowulindela phambi konondelo labo eMorocco kumdlalo ozabe ujongwe ngamehlo abomvu. Stika Stanton Fragnes noliqala le-Kaizer Chiefs uthi uKhamabhili athi usindile ezembeni kubadlali abaliqela abathe bakhululwa liqela eli le-Kaizer Chiefs phambi kwale season. Siya kuyo iqala le-Orlando Pirates. uTebogo Moloi uthi uBen McCarthy ngesithathu isikhundla sokuqeqesha iqela eli le-Orlando Pirates emveni kokuba amabhakabhaka athe amkhulula ke omnye obelisekela lika Mandla Ncikazi okanye co-coach uthiwa bakanti ke uyakhululwa kuthiwa hayi naye ngesithatha esisikhundla. Imidlalo wasesiswini Orlando Pirates uThembi Nkosi Lotha uthi bengakulindelanga ukubiza uqela lesizwe iBafana Bafana. Uthi my call up to the Bafana Bafana squad was too soon. Utsho ke uThembi Nkosi Lotha mina imizuzu phambi kwentsimbi yesithandathu the final whistle with Manez. Bernard Parker will leave amakhosi ngoJune emveni kokuba iqela lingazusivuselela isivumelano sengqesho kunye nalo mfowethu wabakanti uzibandakanya neliqela ngonyaka ka-2011. That's it from my side. Let's conclude the discussion here to Mr Nomvethe. Just one last time, what can we expect now, Mr Nomvethe? What can we expect as the public, as abantu baseMzantsi Africa? What should be on our toes? What is highly possible to unfold with regards to a trial? Iwayisakubona nozinto eBafana Bafana kunye nekapteni uSenzo Meyiwa.
Ngesixhosa benzathi masive sizole. Yayibona. Sizole. Sibe ready for surprises.
Yeah.
Because this is a very big trial. Let's just not put pressure, sizole.
Yeah.
And you say, what can we expect? A lot of surprises.
A lot.
That is what we must expect.
Surprises.
A lot of surprises will unfold here. More especially from the defense side. I'm not going to comment much on, the advantage of the state is that they take statements from witnesses.
Yeah.
And you can preview those statements and see and know who says what. And you know the number of witnesses they are going to call. But for the defense, they don't take any statement. They take a witness to the box.
Yeah.
Which is a shock to the state as to what is going to be said there. So hence I'm saying from the defense side, wait for surprises.
All right.
Expect surprises.
All right.
You will get some surprises.
Thank you so much.
The first one we got, that Kelly is allegedly the one who shot the guy.
Yeah.
It's a surprise. It's not proven, it's not tested yet, but it's a surprise that everybody is shocked of. So we don't know what else will surface. So,
all right.
So let's wait and see.
There you have it, Mr Nqaba Nomvethe. Where do people get contact or get hold of you? And then,
Yeah, we wrap up. Guys, my office is in first floor, Global House, at number 3 PS Street in Beria. Just closer to the hospital.
Okay.
That is called, what's that hospital again? The one in Beria. Just forgot it now, but closer to that Medicross. I think it's Medicross.
Okay. No,
yeah.
Thank you.
And then you get me on Facebook. I'm Nqaba Nomvethe. Instagram, Nqaba Nomvethe. Twitter at Nqaba Nomvethe.
All right.
And you can call me 0781769185 or call my office at 043 721 1208. Yeah,
Right.
yeah, that's
Right.
it. Thank you very much.
Thank you so much for coming through, Mr. Nqaba Nomvethe. From my side, ladies and gents, thank you so much for coming through. Thank you so much to everyone who commented on Facebook. We really appreciate your contribution to the program and being with us for we've been discussing this for more than 2 hours now, and I cannot thank you enough for making sure that nihlala nathi. To everyone, if you just joined us, you missed out, but Ken, we're gonna share the video just now. Make sure that you check it out, you listen to it, you watch it, and on next week we are going to be having another discussion. Probably there will be other things to talk about. From my side, good night and God bless. Thank you so much.